Great. I'm going to kick off with some introductions. Hi, I'm Ollie Percy. I'm a barrister at Garden Court Chambers. I am not Amanda Weston QC, quite obviously. Unfortunately, Amanda is unwell this evening. I'm stepping in to fill her very big shoes as chair. Delighted to welcome you all to this Garden Court Chambers webinar on public law issues with statutory instruments. And to give some context about how important this issue is, I thought I would quote an expert on these issues, Dominic Cummings, or at Dominic2306 on Twitter, and an exchange that he had with David Gauke, the former Justice Secretary, at 1747 on the 22nd of July 2021. And what Dominic said was, like most in SW1, you haven't noticed the important cap locks, secondary, loud noise to emphasize the caps, legislation changes pushed through last year, which we barely discussed publicly so MPs wouldn't get overexcited. And what overexcited means might be discussed later. That's already improving things regardless of what happens with next phase. So it was an interesting observation by someone who was at the heart of government about the central role that statutory instruments were playing in lawmaking and governance of this country. And it seems an important time for us to discuss the public law issues that arise from the increasing use of statutory instruments with minimal parliamentary scrutiny. Joining us this evening, we have an expert panel, and I will introduce them in the order that they will be speaking. So first up, we have Dr. Tom West from the Hansard Society. Tom joined the Hansard Society in July 2021 and is focused on its programme of work on how Parliament legislates, in particular being responsible for the coordination of its delegated legislation review. Tom conducts research for the Society on legislative processes and procedures and supports its collaboration and partnership with other stakeholders and networks active in the field. He has a PhD in international human rights and environmental law from the University of Nottingham, which he completed in 2017. Alexandra Sinclair will be up next after Tom, and she is a research fellow in Brexit, Parliament and the Rule of Law at the Public Law Project, where we were colleagues. He has an LLB honours from Victoria University of Wellington, New Zealand, and an LLM from Columbia Law School, where she studied as a Fulbright scholar. He coordinates PLP's SIFT project, Statutory Instrument Filtering and Tracking, and he is also a PhD candidate at the London School of Economics. Then we'll be hearing from Michael Etienne from Garden Court Chambers. Michael has a broad public law and human rights practice encompassing actions against the state in various forms, but with a focus on cases involving detaining authorities, particularly police forces and prisons. He is frequently instructed on cases that give rise to issues of systemic discrimination, whether in the detention context or in his education law work. Before joining Garden Court, Michael was the Advice and Information Officer at Liberty, responsible for coordinating their public legal advice service. So as you can see, we've got a really brilliant panel for you this evening. And without further ado, I'm going to pass over to Dr. Tom West to get us started. Thank you very much, Tom.
Thanks, Ollie. Thanks for the invitation to come and speak to everyone this afternoon. It's great to be here and talk about this very important issue, which we'll hopefully get excited, if not overexcited, about. And it is great actually to see the issues of SIs receiving growing attention. Like Ollie says, I work at Hansard Society on our review of delegate legislation, which I'll talk a bit more about shortly, which is essentially looking to improve how SIs are made and scrutinised, which is lucky because that's what I've been asked to talk about. So I'm hopefully going to share my screen now. So please wave if you can't see anything. So to kick off, as a bit of a warm-up, let's talk about statutory instruments, or, well, what I'm calling here the law of the everyday. And I think as many people here will realise that this is, most law really is found in statutory instruments or delegated legislation. It's not some sort of small minor part of law. It is things which affect so much of our daily lives, people's lives, and how businesses operate. And again, worth saying at the outset, that's appropriate. It's a necessary way to legislate. There is a need to elaborate the technical details of how law works. There's a need to be flexible and adaptable. There's a need to act quickly, in particular in times of crisis, and delegated legislation, SIs, are appropriate for that. The flip side is there's a lot of it. As you can see, over 1,600 SIs laid before Parliament since the last election. And that's not counting all those SIs which are not even laid before Parliament. And parliamentary scrutiny of them is weak. Now, of course, this enormous number plays a factor in that, but as we'll go on to see, the very procedures themselves could also be improved. Brexit and COVID have, I think, really shone a light on the issues. They have raised the concern, so more people are aware of the problem. But I also really want to impress on people that it's not just a problem just for Brexit and COVID. The issues with SIs predate Brexit and COVID. They will post-date Brexit and COVID. Let's look not least to the recent announcement by Lord Frost of the review of retained EU law, where they'll be looking to set up a tailored mechanism for accelerating repeal or amendment of this retained EU law. How will that be done? So in terms of, I just want to also just share this graph from some of the data we've been collecting at the Hansard Society on SIs. This is showing SIs since the pandemic began. And you'll see in dark green, lots of SIs related to COVID. And I think we all know there's been a huge amount of regulating via SI for COVID and problems associated with that. But look too at the light green. Those are the non-COVID SIs. Lots and lots of them too. So how is it scrutinised? There are a number of different procedures through which Parliament will scrutinise statutory instruments. And I've sort of put those into three categories or buckets here. The negative procedure, as you can see, most SIs are subject to the negative procedure, where no debate or vote is required for an SI to become or remain law. There is a process by which a member can pray against an SI, and if the government tables time for it, there can then be a debate or a vote. That's in the Commons. In the Lords, there is more likely to be that, but it remains in the hands of government whether it will be there or not. One rung up on the sort of rigorous level of scrutiny, you have the affirmative procedure. Now, for these, there will be a debate and vote on the SI, either in both houses or just in the Commons for certain instruments. However, debate, certainly in the Commons, is capped at 90 minutes, and it's normally in a non-specialist committee. That's important. I'll come back to that later. Of course, no amendment is possible. Same is true for negatives. And then there's also a whole host of strengthened scrutiny procedures. There's at least 17. You can count them in different ways. They're relatively rare, as you can see, and they have various different sort of nuances or focuses. Essentially, they all have these additional requirements, which I list on the slide. Public consultation, for example. Worth drawing attention to the fact that very rarely there are powers for a parliamentary committee to recommend changes or even to veto. So in strengthened scrutiny is things like remedial orders under Human Rights Act, legislative reform orders, public bodies orders. There's a few different procedures. I also want to draw attention to the fact that as well as the instrument itself, there's a host of supporting documents that must be laid before Parliament, explanatory notes, memorandums, and so on. These can be very useful documents because their purpose certainly is to explain in plain language, in plain English, what the SI is doing, and in particular looking at the explanatory memorandum, taking it with the landscape, saying what the scope and purpose is, the background, links to other SIs. And these can be incredibly useful documents to unpick and understand what an SI is doing, why it's doing it. Of course, that's dependent on them existing and being of a high enough quality, which sadly is not always the case. Wanted to share a couple of flow charts as well, which I think are quite useful ways to understand the procedures. Talked about the difference between negative and affirmative already, but a few other distinctions that I think it's worth sort of making. Starting at the top, you'll see both negative and affirmatives can either be laid after making or laid in draft. Worth distinguishing, laid is when the SI is laid, presented to Parliament. Made is when the SI is signed into law by the relevant minister, sort of almost like royal assent for an SI. And worth noting that the use of the made affirmative, where an SI comes into law before it's been debated or voted on in Parliament, it's becoming used very frequently for COVID regulations. Moving down the flowchart, we'll see the debates, and again, just want to draw attention to the fact that debate will sometimes be held in committee or sometimes in the whole House, and that will obviously affect the nature of the scrutiny. And then lastly, at the bottom, you'll see that instruments can not become law or be rejected by either House, of course, for those instruments which are scrutinised by both Houses. Of course, in 2015, when the House of Lords refused to consider an SI, led to a lot of concern and the Strathclyde review, which we may talk about later. Just another graph here, just to demonstrate what I was saying about the use of the made affirmatives for COVID regs. Of course, they're urgent, and again, of course, there's a legitimate use for these, but it does, of course, also bring questions about scrutiny, accountability, and democratic legitimacy. So 21.3% you'll see there. And that compares to 4% of non-COVID SIs since the general election being made by the made affirmative procedure. So I mentioned committees a couple of times. Committees are crucial. They're in some ways sort of the engine room of parliamentary scrutiny of SIs. So I think worth talking through the different roles of the various committees. Starting with the JCSI, this body is responsible for checking legal issues, technical quality. It does not look at merits, does not look at policy. So it will be checking for issues such as whether or not the instrument is within the vires of the powers, look for defective drafting, sub-delegation, other technical issues like that. And as well as issuing a report to the House for consideration, we'll also sometimes engage in correspondence with government departments to rectify issues where possible. The JCSI, like the SLSC, it's not sort of formally debating instruments, but rather providing reports for the House to assist in their scrutiny. So the next, the SLSC, the House of Lords Committee. Now this will look at the policy content, and in fact will normally be the most thorough review of the actual policy content of an SI. Again, it's not formally sort of debating, but it can draw attention of the House to particular SIs, which it thinks might be politically or legally important, give rise to issues of public policy of interest to the House and various other reasons where it may feel necessary to bring that to the House's attention. Moving on to the House of Commons and delegated legislation committees. Now, the delegated legislation committee in the House of Commons are perhaps in some ways the weakest link in the scrutiny procedure for statutory instruments. This is not a standing committee, unlike the JCSI and SLSC, and that has implications in terms of staff resourcing, in terms of sort of institutional memory. MPs will often be appointed to DLCs at relatively short notice. And they're frankly often seen as a bit of a waste of time. It's not usually a place where really sort of thorough and detailed and considered scrutiny of the content of an SI will take place. Debates, as I said, will be maximum 90 minutes, but they'll frequently be less and frequently essentially consist of a statement by the government minister followed by a response from the opposition. The last committee worth mentioning is Esic, the European Statutory Instruments Committee. Now, this was set up to play a sifting role for EUA Withdrawal Act SIs. And under this sort of procedure, negative SIs would be laid before Esic, and also the SLSC would play this role for the Lords. And the committee could decide to recommend that the scrutiny be upgraded for that particular instrument. And I think that's notwithstanding the fact that the affirmative procedure, as we've seen, does still have its limitations. What's interesting is it shows Parliament taking control over what the scrutiny of an instrument will be and ought to be. Now, as I've said, the system's not perfect. There are problems with it. And I just want to outline some of those here. First of all, delegated legislation, it is used to develop policy. It is used to cover matters of important issues of the day. It's not used simply for sort of mundane technicalities. Yes, a lot of SRIs are doing that, but it's not only what is done with it. Now, of course, there's no precise boundary about what can and cannot or should not be contained in delegated legislation. We have no constitution which does or could set that out. But clearly, this is seen to be increasing. And even we also see sometimes powers and delegated legislation being used to develop policy which simply hasn't been fully developed yet by government. In fact, we recently published a blog on the Nationality and Borders Bill, which contains a number of placeholder clauses which set out regulation-making powers because government has not yet finalised its policy direction in those areas. So connected to this, we see scrutiny procedure being predetermined by the Parent Act. So that can often be years or decades old. And that, I think, links to what I was saying about Esic and that Parliament taking control of that instead. The growing number of powers, there are very wide powers available. Again, much discussion around that, particularly around Brexit. Yet we're using the same procedures. Are they fit for purpose? MPs are very busy people. They have limited time. They have limited resources, and that impacts on the scrutiny which Parliament's able to give to this kind of law. That's obviously problematic. In terms of resourcing, the House of Commons in particular is hit hard by this because it doesn't have the SLSC, which is able to do that scrutiny. Both the SLSC and the Commons, therefore, often were reliant on external stakeholders giving their views and analysis of SIs. It's an interesting thing about what other models are available. There's a body called the SSAC, the Social Security Advisory Committee, which is an NDBB, which will review and advise on social security SIs. And I think interesting as well to think about what the proper role for Parliament is in reviewing technical data. As I've mentioned, the parliamentary timetable is controlled by government. There are risks if accompanying documentation is of a poor quality or sometimes even missing, particularly given that the SLSC and JCSI are essentially documents-led committees. They're rarely they can, but it's rarely looking at oral evidence. And also, of course, no power to amend. Without that power to amend, then the ability for MPs, the ability for Parliament to change, to improve the law, and also to increase the political jeopardy is, of course, severely restricted. And that ties in as well as to where MPs and parliamentarians' time, resources are best spent. If they're unable to actually really influence the process, why should they commit their time to it? And lastly, the processes are convoluted. They are confusing. There are many of them. They're intricate, they're detailed. And that's not just a problem per se, it's a desire for neatness, but it can also impinge on transparency and people's ability to understand what the law is and how it is made. So lastly, I just want to talk about what we at the Society are doing relating to statutory instruments and a couple of projects in particular to draw attention to. So we have an SI tracker. So this is a subscription service, which it's a monitoring service, which tracks progress of all SIs that are laid before Parliament, as well as consultations, seeking to sort of smooth out some of that complexity which exists in those procedures. And it's also used to provide data for those graphs I shared earlier, and we have a publicly available coronavirus SI dashboard on our website. And also, as I mentioned, our new project on a review of delegated legislation will be running over the next 18 months. But we think there's plenty of evidence, there's widespread views held that the system needs improving, it needs reform. So we want to develop and promote concrete proposals for that reform, what that should look like. So we're going to be setting out some of the ideas in some discussion papers and hosting events over the coming months. Please do contribute and join in. We do want to hear others' views. We want to hear others' expertise and others' insights into this matter. And we think, look, we need to look towards a new Statutory Instruments Act and how that can help to solve the problems we're looking at. There may be other avenues as well, changes to standing orders and so forth. At an overarching level, what do we think a better system would look like? Well, we think it's one that's more responsive to parliamentarians' needs. It allows them to break the link between the power in the Act and what's in the SI, to sort the wheat from the chaff, so they can focus their time and energy on what matters to them, what's politically salient. One which is more influential. Now, of course, that's to do with amendments, Whether that's full amendments or perhaps a bespoke procedure will be interesting to consider and debate, and less bewildering. Like I said, to be transparent, to be democratic, these processes need to be understood and understandable. Okay, thanks very much. Couple of plugs, but back to you, Ollie.
Thank you so much, Malcolm. That was fascinating. I'm going to hand over straight away to Alex.
Hi everyone. I don't have an exciting slide deck with great visualizations that Tom had, but Tom's presentation has been very helpful because it takes the heavy lifting out of explaining lots of those technical terms, which means I can just take it as read that you know now know all of those things, and I can kind of talk about a project that the Public Law Project has been focusing on this year, which is kind of a more recent aspect of the SIF project. And that's been that we've been analysing statutory instruments that have been successfully judicially reviewed in the courts over the last 7 years. And the reasons why we're focused on this is because the government have suggested that they're looking at changing the way delegated legislation that is incompatible with the Human Rights Act is treated. And they've suggested that the Human Rights Act should be amended to prevent subordinate legislation being invalidated on the grounds of incompatibility with convention rights, because the government says that this power is currently being subject to judicial overreach by the courts. And so what our research in fact shows is that judicial review of delegated legislation under the Human Rights Act does not unduly interfere with executive lawmaking. And in fact, it kind of barely interferes with executive lawmaking at all. So what we did was we compiled a data set of cases where delegated legislation was successfully judicially reviewed under the Human Rights Act. And we did that by going through legal databases for all final decisions handed down by the High Court and the Court of Appeal of England and Wales and the UK Supreme Court between 2014 and 2020, in which the lawfulness of a statutory instrument was challenged. And there are not many successful challenges to delegated legislation under the Human Rights Act. In our sample, we managed to identify 14 cases in the last 7 years. So to put that in context, each year there are on average between 1,500 and 2,500 statutory instruments laid. In fact, there was a peak of 4,000 in 2001, and yet only 14 in the last 7 years have been successfully challenged on Human Rights Act grounds. And therefore, you can see from that that the role of the courts in reviewing delegated legislation under the Human Rights Act is pretty marginal. And furthermore, the scrutiny that a piece of delegated legislation receives when it is judicially reviewed in the courts is not infrequently the first substantial scrutiny it has ever received, and it is almost always the most rigorous scrutiny. So as Tom has been explaining to you, delegated legislation is subject to very weak scrutiny processes, and parliamentary processes, essentially, they're virtually habituated to approving statutory instruments. So I thought I'd give you some more examples of these very weak scrutiny processes. So the government of the day, as Thomas said, has control over whether a debate on negative SIs occurs. So in the 2015-2016 parliamentary session, only 3% of negative procedure SIs were debated. During the Brexit process, only one negative procedure Brexit SI was ever debated. The government also has control over the membership of delegated legislation committees for affirmative procedure debates, and MPs and peers are not allocated to delegated legislation committees based on their technical expertise. So they're often reviewing instruments in subject areas of which they have no familiarity. There's also, as we heard from Tom, regularly insufficient time to debate these instruments to afford them proper scrutiny. So some examples from our Brexit research include the product safety and metrology regulations, which were 619 pages long and debated for 52 minutes in the Commons and 51 minutes in the Lords. The aviation safety regulations, which were 146 pages long and debated for 21 minutes in the House of Commons. You know, aviation safety doesn't sound like they're doing anything important. And the financial services regulations 2019, which are 26 pages long, made 36 different amendments to existing legislation, which Lord Tunnicliffe described as having no theme or interrelationship. And they were debated for 11 minutes in the House of Commons. Furthermore, MPs and peers are also regularly provided with inadequate explanatory material, which makes scrutiny of these instruments even harder. Explanatory memoranda needs to be of a high quality because it's often difficult to understand what a statutory instrument is doing on the face of its provisions alone. And so during the Brexit process, the SLSC, which Tom described to you, the Secondary Legislation Scrutiny Committee, frequently criticised the government for the poor quality of the explanatory materials provided. And as the Hansard Society have previously stated in their reports, as long as the quality of explanatory memoranda is below what Parliament ought to expect, it almost ensures that MPs and peers will not take up issues of concern with statutory instruments because much of the process is impenetrable to them. SIs also received minimal consultation. Less than 10% of Brexit SIs were subject to any form of consultation, and only 9 received a full formal consultation. Generally, statutory instruments also face no realistic prospect of defeat within Parliament. Only 17 have been rejected in the last 65 years, and none in the Commons since 1979. For the 622 Brexit SIs laid before exit day, none were subject to a fatal motion debate, and only 2 received motions of regret, which have no practical effect. And this is in the context of Brexit, a highly contentious political event. And so for these reasons, while courts do recognise that delegated legislation has the technical approval of Parliament, meaning that caution should be shown when reviewing it, the courts have also recognised that the level of parliamentary involvement is often very slight, and that therefore strengthens the case for review by the courts. And this is particularly true in relation to legislation passed under the negative resolution procedure, as Lady Hale recognised in the Tajeri case. So 6 out of the 14 successful challenges in the dataset I've described concerned challenges to SIs that were made via the negative resolution procedure, meaning a copy was simply laid before Parliament and there was not a debate over that instrument. Furthermore, when we looked at these 14 cases, we saw even less evidence of judicial overreach. So we in fact saw that decision-making in this context was characterised by judicial deference rather than judicial overreach. Not only are there many more unsuccessful challenges to delegated legislation than there are successful ones, but courts often grant the executive significant leeway when considering economic and social welfare policy. For example, in Crown and Carmichael, the bedroom tax case, the courts were very careful to restrict the scope of their ruling to the specific aspects of the scheme which failed to pass scrutiny. And finally, even when courts do find that delegated legislation is incompatible with the Human Rights Act, it doesn't mean that that statutory instrument is inevitably struck down. The quashing of a statutory instrument is a discretionary power, and it's one that's rarely used. So of those 14 cases I've referred to in which human rights challenges to delegated legislation succeeded, the courts quashed or disapplied the offending provision in just 4 of those 14 cases. So the need to respect, parliamentary sovereignty is why primary legislation is subject only to a declaration of incompatibility under the Human Rights Act. But by contrast, delegated legislation, as I've explained, has received much less parliamentary scrutiny. And so review of that delegated legislation by the courts doesn't undermine this careful constitutional balance between Parliament and the courts. And in fact, we would say it enhances that balance and enhances the rule of law by ensuring that delegated legislation is in fact compliant with UK human rights law. Thank you. I'll throw you back to Ollie.
Thank you so much for that, Alex. That's really striking research. And there is a note in the chat, which I'll go to now, which is from Jodie Beck at Liberty, saying that's really interesting research, Alexandria. Correct, it is. Is this published online?
Yes, I can send a link to our UK Constitutional Law Association blog that we published on this earlier this year. I'll post it in the chat.
That's brilliant. Thank you so much. So next up is Michael Etienne from Garden Court Chambers. So Michael and I are covering challenges to statutory instruments through judicial review. Michael will be covering grounds, and I will then be picking up where he leaves off, looking at issues of timing, what part parliamentary scrutiny and how that's relevant, and judicial review reforms. So over to Michael.
Thanks very much, Ollie, and thanks everyone for joining us. I am just about to start sharing my screen, which is normally a sign for my laptop to go into some kind of crisis, so keep your fingers crossed. I should say, while I'm doing that the purpose of this presentation is not to provide a detailed analysis of each of the decisions that I'm going to go through in terms of illustrating the grounds. And that's partly because, as we'll come to see, a number of the decisions cover a lot of ground, including some important elements of the requirements in relation to claims under the Equality Act and under the Convention, which unfortunately we just don't have the time to cover in the very short slot that we have. So this is slightly more of a whistle-stop tour introduction to some of the key points to draw your attention to. Firstly, Ollie, can you just give me a thumbs up if you can see the presentation? Thank you. Just run it in full screen. There we go. So we're looking at grounds of challenge for judicial review against statutory instruments. Many of you will be familiar with the classic statement of law in relation to the general grounds of judicial review in the Civil Service Unions case, which has been repeated many times in the 30 plus years since. Of course, classically, illegality, irrationality, procedural impropriety, and of course, in more recent times, incompatibility with ECHR and or EU law principles, of course, the latter prospectively having potentially less significance, at least in the domestic context. But looking specifically at secondary legislation, and some of the other speakers have helpfully covered the context for this. But a lot of the principles that were referred to earlier are also recognised in the judgments. And I'm going to take you through a couple of paragraphs in the judgment of Lord Neuberger in PLP and the Lord Chancellor from way back in 2016, which was a challenge to the regulations which gave effect to some of the provisions of the Legal Aid Sentencing of Offenders Act, LASPO, and the very significant changes to legal aid. And of course, we have a very general statement in paragraph 20 about the nature of primary versus secondary legislation, and the court noting that obviously there's much less scrutiny, as we've heard, of secondary instruments. There we go. And I think quite an important point that when we're dealing with secondary legislation and the limits of amendments, and of course, in terms of these general principles, COVID too has meant that there's almost not an aspect of daily life that hasn't been touched by secondary legislation of some form or another. Of course, the entirety of lockdown was effectively given effect to by regulations. And although I'm not covering it this evening, many of you will be aware of the decision in Dolan, the unsuccessful attempt to judicially review a later iteration of the lockdown regulations. But in terms of grounds, what are we dealing with? Well, we can start by going back to the dictum in the PLP case, and a kind of, I think, a neat statement of principle there, that subordinate legislation will be held by a court to be invalid if it has an effect or is made for a purpose which is ultra vires, that is outside the scope of the statutory power pursuant to which it was purportedly made. And I think it's worth emphasising that it's illegality if it has, not only if it's made for a purpose outside of the relevant legislation, which one might think is slightly easier for a minister to avoid the mistake of doing, but also the effects. And a number of the successful cases are about the effects of secondary legislation vis-a-vis the primary legislation. Let's see. Sorry, I've just skipped forward one slide. So we've seen, in fact, two recent examples, which I haven't put on the slide, but we've had Amanda Weston of these chambers has had a successful challenge to an attempt by the Home Secretary to cancel the claimant in that case, known as C1, their indefinite leave to remain in the United Kingdom whilst they were outside of the jurisdiction. And the Home Secretary had sought to rely on the broad general powers given effect to under immigration legislation. And one of the important points that the court made in that judgment was effectively that that broad power couldn't be read as giving the Home Secretary a power to limit or to stop the indefinite leave to remain of the claimant. Position might be different for those with limited leave to remain, but in the context of somebody who's been given the relative assurance of indefinite leave to remain, the Home Secretary had gone beyond the scope of her powers in seeking to stop the claimant's indefinite leave to remain. Another example, and again, perhaps familiar to many of you, is a successful challenge on behalf of rights of women in relation to the very onerous approach that was being adopted effectively by the Legal Aid Agency for victims of domestic violence to satisfy them that they were in fact victims of domestic violence. And effectively, the approach taken in that case was so significant that a large number of people found that they were being denied legal aid, and the court found that that approach was entirely inconsistent with the primary legislation, because the whole point of the primary legislation was that certain groups of people were, by decision of Parliament, entitled to be awarded legal aid, and the effect of the approach of the Legal Aid Agency was to exclude those that Parliament had intended to benefit from. So that's ultra vires and illegality. Moving then, let's see, to irrationality, a more recent decision. I've cited there on the slides for you a case of Salvato, which was a challenge to the Universal Credit Regulations 2013, and in particular the provision of the regulations that dealt with the reimbursement of childcare costs. Slightly complicated regime, but in essence the way that the scheme worked was that you were entitled to recover certain childcare costs, the scope of which was defined in the regulations. But the basis that you recovered your costs was that you were reimbursed based on what you'd already paid out, rather than your liability to pay. And as the claimant's situation illustrated in that case, that caused all sorts of practical difficulties, partly because the way that the accounting worked for benefit purposes, and the fact that most people, or a great number of people, get paid monthly, meant that in some months, when assessing what costs were recoverable, which had to be done by reference to a person's income, sometimes they'd be assessed on the basis of having been paid effectively 2 months' income, and in other months they would have no income to assess. And the claimant in that case was one of a substantial number of people who basically found that they had to get into debt in order to meet their childcare costs because they could only be reimbursed for them. That reimbursement, typical of the approach of the DWP, in my experience, took several weeks and wasn't always without difficulty. And effectively, again, what that meant was that very vulnerable people that were intended to be provided for under the regulations were denied, were effectively frustrated in accessing that benefit. One thing that's always worth bearing in mind, the threshold for irrationality is a high one, and we can see an indication of that there in the passage that's on the screen, where the court emphasises that a policymaker may reasonably decide that the disadvantages of a finely tuned solution to a problem outweighs advantages, and that a broader measure is preferable, even if the broader measure is both over and under inclusive in that it catches cases where there is no significant problem and fails to catch some cases in which problems occur. And this is effectively an approach that's adopted by the administrative court in Salvato. But the key question, and I highlight it at the end of paragraph 123, is whether or not a reasonable balance has been struck, in this case by the Secretary of State for Work and Pensions. Or rather, is it possible to say that no reasonable Secretary of State would have struck the balance in the way that the Secretary of State for Work and Pensions has done in this case? So that's obviously quite a high threshold. Sorry about that. But as the court said in this case, it's not insurmountable. And in this case, it did ultimately succeed. Of course, every case on its own facts, although it succeeded in this case, the evidence of the impact was well illustrated as part of succeeding in this judgment. Suffice to say, of course, though, that and this is perhaps pertinent in the context of COVID and the different ways in which the state is responding to dealing with COVID, that the courts, I think, will be slow to find in the quote unquote exceptional circumstances of the pandemic that discretions have been overused, and perhaps Dolan and the failure even to obtain permission in challenging what on any view is a significant legal regime in terms of giving effect to lockdown probably indicates the reticence of the courts in approaching some of these issues. And so some of the key considerations in assessing irrationality in the context of this case was that so the argument had effectively been run that the scheme that had been adopted for reimbursing childcare costs was a decision completely within the gift of the within the scope of the minister's powers, and that effectively considerable deference ought to be paid to it in the circumstances, and it was a deliberate choice of systems. Well, on the deliberate choice point, the court noted that yes, there had been a deliberate choice and consideration given to the nature of the system of the scheme that was to be introduced, but there was less evidence that the specific effects of implementation that were at issue in this case had been considered. And in fact, the minister had not recognised, this wasn't a situation where a minister could potentially say, well, I've recognised the problem, and for these other reasons, I've decided not to do anything about it. And that sort of is a callback to the idea of finely tuned decision making. But that isn't something that happened in this case. As is common in this context, it was said that the cost of fixing the problem of which the claimant complained would have been considerable. And again, the court found in that case that the evidence about the cost implications for fixing the problem was largely generalised and about the administration of the system as a whole, as opposed to specifically tailored to the cost implications of fixing the particular issue that was being challenged. And a fifth point there, that the justifications for the general rule, that is to say, the general scheme did not adequately explain the need to maintain effectively reimbursement after payment rather than having a scheme based on liability to pay. So just to clarify that, the minister had said effectively it was the state's decision as to what systems to implement, and the court should be slow to interfere. And effectively, the court recognised that as a general principle. But the specific question was whether or not there was sufficient justification for this particular aspect of the measure, because of course it was that aspect of the measure that had the negative impact on the claimant. And this was a claim that was brought not only on the basis of common law irrationality, but also on the grounds of ECHR discrimination, contrary to Articles 8, 14, and the right to property under Article 1 of the first protocol. So, of course, the court had to eventually get to a point of looking at the discriminatory impact and assessing the discriminatory impact of the measure complained of, as opposed to just generally looking at the scheme as a whole. Another basis, another potential ground of challenge is about lack of consultation. The public law duty of consultation, of course, has been rehearsed in a number of cases, but the recent decision following the challenge brought by Article 39, which is a children's rights charity, I think is a powerful illustration of the importance with which the courts will approach the duty to consult in difficult and challenging circumstances. So this was a claim against various regulations that had been introduced at the height of the pandemic to effectively water down certain legal requirements that related to the regulation of childcare placements, the timescales for social worker visits, provisions in relation to adoption of especially young children, and so on. So on any view, very important aspects of effectively a safeguarding regime for children in care. And interestingly, the government had argued, amongst other things, that effectively the changes implemented by the regulations were fairly minor, a suggestion that was given fairly short shrift by the court, which noted that the significant and substantial impact of what was being proposed. And in essence, the duty of consultation really bit in this case with respect to the Children's Commissioner. And so what had happened in the course of the relevant regulations being promulgated, there had been some informal consultation with the Children's Commissioner and other interested parties, effectively by way of an email. But there had been no substantive consultation thereafter. And one of the points on which the case succeeded was that there was a lack of consultation. And the duty of consultation really took hold in this case for three reasons. First, there's a statutory duty in this context to consult with the Children's Commissioner and other named parties. There was also something of an established practice because there had been some informal consultation in the specific context of these regulations. And of course, it was the experience of the Children's Commissioner that they would quite obviously be consulted, generally speaking, whenever the government was proposing to make significant changes in relation to matters relating to the welfare of children, because that is the very purpose for which the Children's Commissioner exists. And thirdly, because of the scale of the impact of the changes and what it would mean in terms of potentially reducing the height of safeguards for vulnerable children. And interestingly, in this case, the claim had failed in the High Court, but succeeded on appeal to the Court of Appeal. And the Court of Appeal judgment is quite strong in its defence of the duty to consult with the Children's Commissioner and others in this case. And Article 39 were unsurprisingly thrilled to have succeeded in this case, which produced, I think, a lot of comment at the time, because it was an example of very significant changes being made under the guise of COVID that had potentially serious implications for vulnerable people. Spare me a second. There we go. And the last aspect I'm going to look at is the public sector equality duty and attempts to challenge secondary legislation in light of the public sector equality duty. So for those who don't know, the public sector equality duty is set out in section 149 of the Equality Act 2010 and requires decision makers, public law decision makers, to have due regard to the need to eliminate discrimination and foster good relations between those who share protected characteristics and those who don't, and also those who aren't public authorities but who exercise public functions. And there are a couple of important points that arise from this case of Adiatu, both in terms of what it says about challenges generally, but there's also an important point it makes in the context of its analysis of indirect discrimination that I want to just flag up to you towards the end of this part of my presentation. I note in the square brackets the key paragraphs dealing with the various issues before the court. The first was whether or not the public sector equality duty applied to decisions that were given effect to under secondary legislation at all. So one of the I should set out the background to this case, which was a challenge to the job retention scheme and the fact that it didn't extend to self-employed workers. And the claim was brought hot on the heels of the success of the Aslan case by an Uber driver who sought to challenge their exclusion because of the nature of how the job retention scheme applies to those who are self-employed, effectively doesn't apply to everybody, and argued that measure was discriminatory or indirectly based on both gender, sex and race discrimination, because it had because the coronavirus pandemic has had a disproportionate effect on communities of colour. The claimant in this case was black, and also had a disproportionate impact potentially on women insofar as their ability or sort of the obligations of childcare falling disproportionately on them during the course of the pandemic. And so it had been argued that the PSED basically didn't bite in the context of secondary legislation. And we can see at paragraph 220 that the court basically rejected that argument and said that it was clear in light of earlier authority, by which in effect the admin court was bound anyway, that the public sector equality duty did apply to secondary legislation and also does apply to the steps taken to promulgate secondary legislation. Now, importantly, it went on to say, though, that the public sector equality duty does not apply to decisions that are given effect to by primary legislation. And effectively, it was a classic Bill of Rights argument. In effect, if it were possible for someone to bring a PSED challenge in respect of primary legislation, then any form of legislation would potentially be the subject of challenge. That would clash with the Bill of Rights and the principle that the proceedings in Parliament can't be impugned outside of Parliament. Principle, of course, that doesn't apply to secondary legislation. And paragraph 230 really marks the starting point of the court's reasoning that centres around the consequences of otherwise enabling parliamentary legislation to be challenged. It's also relevant to note that in Schedule 18 of the Equality Act, there's an exemption in relation to ministers, and the court was satisfied that the exemption under Section 18 wouldn't apply in the context of secondary legislation. But even if it hadn't decided the case on what I'll call the Bill of Rights point, the exception in Section 18 may have come into effect there. The next issue is whether or not the public sector equality duty applies to decisions that a public authority takes or contemplates taking, or whether it also extends to things that the claimant might argue it ought to have considered. That might seem slightly counterintuitive, but it's not uncommon in the context of Equality Act cases, public sector equality duty arguments, effectively to rely on things which the claimant says ought to have been contemplated. On the facts of this case, the court said effectively that the public sector equality duty can't bite on anything which the decision maker isn't even contemplating. So you have to, bringing a PSED challenge, you have to look at whether or not the decision that was taken itself showed due regard to the public sector equality duty. And in that context, there's a reasonable amount of discussion, as one might expect, about the fact that the duty is one of due regard. It's a procedural obligation, and the court noted that although there are a number of authorities which obviously illustrate that that is a duty that must be engaged with robustly, it's not a duty that the court is going to take in effect to stipulate steps which must be taken. What the court has to look at is whether or not conscientious consideration has been given to the relevant issues, and if it has, then the likelihood is that a claimant will not gain much benefit from seeking to rely on the public sector equality duty. Having said that, of course, we also have in other contexts recent and important successes relying on the public sector equality duty. And for anyone who's interested, a decision at the end of last year, I think, in relation to the use of facial recognition technology by South Wales Police. So it's I wouldn't want to give the impression that the case law is going in one particular direction against claimants. I said I wanted to flag a point about the court's approach to indirect discrimination in these cases. Now, effectively, you can see there that the court accepted a submission from the government that the way that the job retention scheme had been set up and the rates that had been set for statutory sick pay couldn't be a policy criterion or practice within the meaning of the Equality Act, because the disadvantage disproportionately faced by Black communities and women in this context weren't the result of the rates that had been set for the relevant payments at all. The court said they were caused effectively by extraneous factors, and those extraneous factors couldn't turn the relevant matters in dispute into a policy criterion or practice. And went as far as to say, as you can see there, in our view, the EU law challenge is wholly unsustainable. That's actually quite a striking line of reasoning, because it's difficult. I mean, it seems to drive a coach and horses through some of the basic principles of indirect discrimination on one view, at least in as far as the whole point about indirect discrimination is that it's not only about the specific measure that gives rise to the unlawful treatment in isolation, but it's that measure, in a wider context. And this is a judgment that seems worryingly potentially to herald a significant reduction in the scope of arguments around indirect discrimination. So it will be interesting to see how that plays out over the months ahead. And that is my whistle-stop tour, I hope, through some potential grounds. Ollie.
Thanks so much, Mike. That was really interesting and thorough, not such a whistle-stop tour. I'm conscious that Alexandra needs to leave us at 6:15. So if anyone has any questions for Alexandra, could they put them in the Q&A box? And if they come up, I will try and interrupt my presentation if I notice them so that Alex can answer them. Let me just share my screen. Dum, 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 dum. Right. Great. Everyone see my slides now? Thumbs up if yes. Great. Thanks very much. So I'm going to be looking through the issue of timing, parliamentary scrutiny, judicial review reform, and I'm going to be going at canter so we can have some time for Q&A. So timing, by this I mean, when can you bring a challenge in relation to a statutory instrument? And the related question of when should you bring a challenge to a statutory instrument? So the ordinary principles of prematurity and ripeness, as nebulous as they are, and a good statement of the principles can be found in the case of Sept, which involves a planning decision. Essentially, the decision must have crystallized to a point where it can be challenged. What does that mean? It means a variety of things depending on the context, which is such a lawyer's answer. You can challenge draft regulations, which was the case of the PLP case against Lord Chancellor, which was, as Michael referenced, about the residence test for legal aid. Those were draft regs that got challenged. Then you can challenge during the process of parliamentary scrutiny. So in the case of TP, which is another universal credit case, and this was to do about transition from legacy benefits to universal credit. It had been through, it was about to be debated in Parliament as part of the affirmative procedure, but when the hearing was heard, but that was not considered to be a barrier to the judge, Mr. Justice Swift, determining the case. So that was not considered premature, which is maybe an indication of how effective they consider the procedure or the potential for the affirmative procedure to actually amend, well, it can't amend, but strike down the regulation before they come into force. You see how powers are exercised. So this is a case of Client Earth, a Marine Conservation Society, which was concerned retained EU law, and I suspect we'll see a lot more judicial reviews about Brexit-related statutory instruments as they come. And this case was an indication why more challenges have not been brought to date. So this concerned the Habitats Directive and the process of retaining them through the Conservation of Habitats and Species Regulations 2017, or the Conservation Regulations. And Client Earth and the Marine Conservation Society were concerned that when these regulations, and Tom used to work at Client Earth, and Alex, I know, also was involved with this, so they're much more familiar with this case than I am. But in essence, there were new provisions put into the statutory instrument that were not in the directive. So this was about management of habitat conservation sites. And it introduced new provisions such as where necessary to adapt and so far as is proportionate. So it seemed to create more powers for the minister to mess around with the habitat sites. Mrs. Justice Lieven, in refusing permission in that case, essentially struck it down on, refused permission on the basis of prematurity, because she said, well, we don't know on the face of it whether it has watered down the effect of the directive, and we'd have to wait to see how the power was exercised. If it was exercised in a way that was out with what would be permitted by the directive itself, then potentially, but the words that had been inserted didn't necessarily mean that the power would be exercised in a way that wouldn't be compatible with the directive. So I think what we learned from that is that where these new tools or avenues for ministers to exercise powers in a slightly different way to how the original EU law envisaged, we'll have to wait to see how they exercise the powers before there's a challenge that could be made to the retaining legislation. The next point I wanted to talk about in relation to timing is the fast changing scenario and when you can bring challenges and when they will be academic. So we all remember, and we're still in the pandemic, the COVID-related regulations that seemed to be published a minute before they came into force and were constantly being changed. And the case of Dolan was one of the more wholesale attacks on lockdown. And it's a case that is quite controversial because it has arguably stimulated lots of the recent reforms in relation to judicial review in the administrative court, procedural reforms, not the wider reforms that are being part of IRAL. But I think Shaw and Dolan are quite interesting cases to compare on what the court's approach will be to academic, whether claims will be academic in a proper sense, and when the courts will exercise their power to hear academic claims applying the Salem principles. So, as I mentioned, Dolan was this case was a challenge to lockdown, and Shaw was a challenge to the special educational needs coronavirus regulations, which temporarily amended the SEND regulations, which provided time limits in the preparation of education, health and care assessments and plans. So really important duties, but there was a recognition by government, or there was a feeling by government that the COVID pandemic made those different duties harder for local authorities to comply with, and therefore they relaxed them. There were a number of ministerial directions that were then made subject to under the powers in those regulations. So ministerial notices even. So what was the different approach between these two cases? Well, in Dolan, whilst the regulations that were under challenge had actually been repealed by the time that the litigation got to court, while the litigation failed as a whole, the court was sympathetic on the issue of them being an academic claim. So the court was said, actually, these are really important issues that need to be addressed. We're not going to knock it down on a technicality. Whereas while in Shaw, the court did actually look at the issues and didn't knock anything back on the technicality in relation to the notices, the court said it probably would have. Just to be clear, in Shaw, there were both regulations and individual notices that were being considered by the court. The notices had expired, and the court and the Secretary of State for Education had said they were not going to issue more notices. The regulations being still in force meant that the grounds of challenge, which nearly all of them related to both the notices and the regulations, needed to be considered anyway. And then the judge had made a hilarious joke that it was academic about whether he needed to consider whether it was academic, because he was going to consider the grounds of challenge anyway. Hilarious. But the court said if they hadn't had this parallel regulations in place and that they had to look at the issues anyway, they would have been minded not to the issues because the Secretary of State had committed not to make further notices. And therefore the issues of the lawfulness of the notices didn't need to be considered by a court because it wouldn't have met the Salem test in effect. So different approaches to sort of discretion to consider a claim even when it's academic, I think, rather than properly the question of whether it's academic. And obviously that was at the peak of the COVID pandemic. We might be seeing another peak, who knows? But I think courts were extremely deferential generally. So it was interesting that they considered Dolan. If it hadn't been such an obviously hopeless case, maybe they would, and also high profile and important case, maybe they would have taken a different approach. Who knows? Because they could easily knock it back when they considered it substantively. Collateral attack, and by that I mean targeting secondary legislation well after it's been made. So you're not considering the date in which it's been made, which is when it's signed, as Tom said, and formally the decision, if you're thinking about when a clock is running for judicial review. But if a decision is made subject, pursuant to a statutory instrument, that decision can be challenged and then can form a collateral and allows you to collaterally attack the regulation. Or there can be some form of pre-PAP saying, look, the discriminatory impact of this legislation has become apparent. You need to withdraw the regulations, etc. And Salvato, the case that Michael spoke to earlier about childcare payment arrangements and universal credit, that case was brought and handed down in 2021. The regulations date more than half a decade from before that, and it was really helpful in terms of evidencing the discriminatory impact for a discrimination claim to see that actually the justifications that put forward by the government just did not add up in practice. So would that have been a successful if brought earlier? Well, TP was a successful Human Rights Act claim that was brought earlier, and one of the very few in Alex's study that of success. I think where there's complexities, such as in the Salvato case, I think it probably did need to see some impact to debunk the justification analysis. Whereas So parliamentary scrutiny, and what I mean by this is what weight will courts give to the lack of parliamentary scrutiny or that is given to statutory instruments. So sure, the special educational needs case that I just mentioned is another useful example. So sure, one of the grounds of challenge that was given permission but was not successful was that it was irrational to lay the regulations a day before they came into force on the basis that it would not give Parliament time to adequately scrutinise this complex piece of legislation that had very significant impacts. So just going to a summary of the submissions, the claimant submitted that parliamentary scrutiny of delegated legislation is an important aspect of parliamentary accountability, and that the accountability of the government to Parliament lies at the heart of Westminster democracy. And that was citing the case of Miller number 2, in which Public Law Project intervened on the issue of statutory instruments and the importance of scrutiny of Brexit-related statutory instruments. And Alex's research played a starring role. That principle of parliamentary accountability and the importance of scrutinising SIs was picked up in the Shaw case and argued by the claimant in that case that the decision to lay the 2020 regs was an exercise of executive discretion over which the courts have exercised a supervisory jurisdiction for centuries. The decision to lay the 2020 regulations the day before their entry into force breached the 21-day convention that there should be a 21-day review, which we've heard from earlier this evening. And the reasons given for that in the explanatory memorandum failed the test of rationality. The claimant also submitted that reliance on Article 9 of the Bill of Rights, which Michael has also mentioned about not impugning Parliament, and parliamentary privilege was misplaced. The manner of exercising a power to lay regulations under a statute was a procedural choice which was a government decision and not a proceeding in Parliament, was the argument of the claimant. And this drew upon the Heathrow litigation a year before, where the Speaker had been a party and talked about when proceedings in Parliament might possibly be relied upon. So what was the outcome? Well, that ground of challenge was given permission, but was ultimately fairly firmly dismissed on the basis that it was not a justiciable matter. As set out on my slides, the judicial exclusion zone applies to decisions to lay delegated legislation, as well as primary legislation before Parliament, except in cases where statute and not merely parliamentary convention bestows upon the court authority to intervene. What in short it was saying there is that this convention was not enough for court to intervene. There had to be statutory provision for doing so. And in any event, the judge said if he was not right on justiciability, it certainly was not irrational, and it drew quite extensively upon the context of legislating during a pandemic and the urgency that was required. So on the issue of proportionality, and this goes to what other speakers earlier this evening have mentioned, essentially, you're not really meant to look at proceedings in Parliament when considering secondary legislation. That's the broad principle. You're not meant to be impugning Parliament. But there are several examples, and that the amount of scrutiny rather than the quality of the scrutiny. So courts will not look at the cogency of the arguments when scrutinising legislation. That would be impugning. But they will look at the absence of parliamentary debate in assessing proportionality. And one good example of that is Matheson, which was the child hospitalization rule for benefit for disability living allowance, I think, where negative inferences were drawn from the lack of parliamentary debate. Ditto Salvato, similar comments were made about it only being a rule that was only in secondary legislation, and therefore had not had the parliamentary scrutiny that was required for it to be when looking at the justification analysis and the intensive justification that was required. I'm very conscious of the time. I want to leave some time for Q&A. Flagging judicial review reform. Alex has already mentioned reform of the Human Rights Act, potentially to limit the scope of attacks, of the potential for challenges based on human rights grounds. And the evidence base that Alex has collected sounds invaluable in debunking some of the rationale for that. But I wanted to briefly talk about prospective-only quashing orders and suspended quashing orders, which are being provided for in the New Courts and Justice Bill, following the independent review of administrative law and the government's response to that. And in short, there are two proposals, and in my view, neither of them are particularly consequential. The first is to suspend quashing for X amount of time, maybe 30 days, to allow for transition measures to be put in place. And then the other is prospective only quashing orders, which would mean that actually, if there's been anyone's relied on those orders, regulations beforehand, or unlawfulness has arisen as a result beforehand, that's not going to be reflected in the order. It's only going to be unlawful from now. I say these are not consequential proposals just because they're powers that the court has anyway in its discretion to grant relief. And I think it's unlikely to change things significantly, but maybe others take a different view. I don't think they're necessary proposals. Anyway, that is the end of my presentation. Thank you very much. I realise an evening of statutory instruments is quite a heavy going exercise, so thank you for sticking with us. If we have, are there any questions? I can't see any in the chat. So I'll give it a minute. If not, I think we can maybe finish a few minutes early and we can all go and have dinner. Actually, I have one question for Tom, if there isn't a question from anyone else. And whilst everyone's furiously typing their very clever questions, I'm sure. Tom, could you briefly go into a bit more detail about the SI tracker that Hansard Society has? Because I have it and I think it's really valuable.
Yeah, sure. So the SI tracker, I can say it's a subscription service, and essentially what we do, I say we, my colleagues do this. They track every single SI that's laid before Parliament and then its progress through Parliament. So this allows people to you can then sort of file and flag the ones which you want to stay on top of, and see what the key moments are as it goes through. So, for example, the SLSC reports on that particular SI, draws attention to the House and says issue that will be linked through to there, and you'll be able to access easily the date when that SI will next be debated or when it's going to enter into force. So it just is it's a sort of one-stop shop place to go to be able to sort of keep on top of, as I say, these sort of overwhelming sort of can be at times a deluge of SIs coming in, and also to help navigate through that procedure. If you do want to know more, please do get in touch with us. We're very happy to explain more. I've also got a question back to you, Ollie and Mike, if any have come through, but if not, then I can.
No, and I quite want dinner. I don't know what anyone else is feeling about on that topic. So I think if it's all right with everyone, shall we call it a day? And thank you very much for the really fascinating presentations. Sorry, Alex has had to leave us. Maybe all the questions were for Alex and nobody's asking them because Alex has gone. Her research is pasted into the chat if anyone's not had a chance to pick up the link yet, which is a blog article by Joe Tomlinson, Lewis Graham and Alexandra Sinclair. And it sets out the research that Alex was speaking about earlier. But if there's nothing else, I think we'll call that a day. And thank you very much, everybody. Slides and a recording will be circulated to everyone who signed up. So I hope you enjoy those and they'll be useful tools for you going forward. I don't think I have power to actually end this, so I'm going to defer to Amy to actually end the presentation this evening, but it's goodbye. Thank you very much.